If you decide that you're just going to try to handle the matter yourself and deal with the insurance company directly, what you need to understand is that the insurance adjuster you're dealing with isn't your friend. He isn't your advocate. He represents the person who caused the accident and his insurance company. And his job is to try to resolve that claim for the least amount of money as possible. Even if you are deemed to be partly at fault for a motor vehicle collision, you still have the right to recovery under South Carolina law. We have a legal doctrine called comparative negligence. And so long as your fault isn't determined to be greater than 50%, then you're entitled to at least to recover a portion of your damages, commensurate with the other driver's percentage of fault. One thing to bear in mind, though, is that just because a police officer tells you that you may have been at fault, or an insurance company investigates and thinks that you may have been at fault, that's not necessarily set in stone. And that's another reason why it's important to retain attorneys like Morton Gettys to represent you in these matters, so that we can investigate, we can follow up with the witnesses, and if necessary, hire the necessary experts to investigate the collision independently and determine what really happened. In most cases, it's commonplace to sue both the trucking company as well as the truck driver. The truck driver is obviously an agent of the trucking company that he works for. And so under South Carolina law, under doctrine of agency, you can sue both the driver and the trucking company so long as that truck driver was working in the scope and course of his employment with the trucking company. And oftentimes, the trucking company might have greater liability than the truck driver himself, depending on the truck driver's driving history, criminal record, and various other elements of his background that might have a bearing on whether or not he should have actually been employed as a truck driver or driver for that company. In terms of what sort of compensation that you're entitled to when you've been injured as a result of a third party's negligence, most people think about typically the medical costs. They think about the wages they've lost from not being able to work. And most people also are familiar with the terms pain and suffering and realize that they're entitled to some sort of compensation for that. But really, the way we define damages from a legal standpoint in South Carolina is much broader than just those three elements. You're entitled to compensation for the nature of your injury itself, for any permanent or temporary disability that you may have experienced, any permanent impairment you may have suffered. You're entitled to compensation for emotional trauma and emotional distress. And you're also entitled to compensation for your inability to do those things that you're used to doing. And whether that's jogging 3 miles every day or playing basketball at the gym every Saturday, or if you're unable to go on vacation with your family because of your injuries, then our law says that that's a part of your total cognizable damages, and you're entitled to compensation for that just as much as you are for your wage losses or the medical bills or anything else.